Good morning to everyone. On behalf of Bharati Institute of Public Policy, Indian School of Business, I take this privilege to warmly welcome all the esteemed dignitaries, delegates, and participants to the third day of the Public Policy Dialogues, Bridging Research and Practice. I would like to inform you that all of our expert panel sessions are getting live streamed on Bharati Institute of Public Policy's official YouTube channel, and we have virtual audience joining in as well. Ladies and gentlemen, I would like to invite the first panel of today, deliberating on a very interesting topic of data and privacy. The panel intends to discuss pertinent issues related to data and privacy, such as the need for greater awareness and education about data use, the potential for data privacy to be used as a tool for surveillance, and the need for a balanced approach to data privacy that considers the interests of both individuals and organizations. I would like to welcome the following panelists: Mr. Kazim Rizvi, founder, The Dialogue; Ms. Anushka Jain, Policy Council, Internet Freedom Foundation; Mr. Ashish Aggarwal, Vice President and Head Public Policy, NASSCOM; Mr. Nikhil Pava, founder, Medianama. I would kindly request Mr. Kazim Rizvi to please moderate the session.
At the plenary on data privacy, very timely because, as we all know, that there's a draft data protection bill which recently closed for public consultation on the 2nd of Jan. And hopefully with 2023 coming in, we will have a new personal data protection law in place, which should hopefully be enacted by the Parliament this year. Really excited to speak to and very distinguished experts over here, all of them who've been taking a very important role in terms of driving the discourse and also informing the policy making process on the privacy law. Glad to have Mr. Aggarwal, Anushka and Nikhil with us. So we have an hour, I think hour 15 minutes. So I'd like to start and sort of focus on various aspects of the bill and also sort of trace back the history a little bit, look at the current state of affairs and also look at the future with respect to emerging technologies, with respect to Web 3.0, with respect to new business models emerging. What does it mean for the Indian ecosystem? I'd like to start with Mr. Aggarwal, if I may, and then I'll come to Anushka and then Nikhil. And then what we'll do is we'll have a sort of round of discussion, maybe 3 to 5 minutes, and then we'll also invite audience to ask any questions if you all may have, let's say after the first couple of round of discussion which we have amongst ourselves. So Mr. Aggarwal, I'd like to start with you. And you've been sort of observing this for many years, and we all have been talking about it for a lot of time now. So I think this is the 4th version of the data protection bill, if I'm not wrong. Hopefully there will not be another version which will again be open for public consultation. Hopefully this will be revised and go to the Parliament. But to start with you, and we are in a business school, right? And there is always this dichotomy that whether industry wants a data protection bill or not. And we've seen NASSCOM do a lot of work with respect to informing policy making process. What's your take in terms of the current draft of the bill? And where do you see this going with respect to supporting innovation in the tech ecosystem and also ensuring that individual rights are protected?
Thanks, Kazim, and happy to be here in the morning. Good morning, everyone. So industry definitely wants a data protection bill. I think the fact that a data protection law can significantly enhance the trust of citizens and consumers means that more data flows can happen, more data can be utilized, and that's good for business. Obviously, it has certain costs. I think where industry likes to intervene and give feedback to the government is really, one, to make sure that a law is implementable at scale. And that's very important because you could have something which seems perfect on paper, but if it can't be implemented at scale, it's a problem. Second is, how can we minimize, if not avoid, ambiguity? So if that is going to lead to a lot of interpretation issues, I think that's going to be a big problem. And third, plain simple, some obligations which don't meet the objective and are too onerous. So I think if we can arrive at the right balance at these three, from an industry perspective, a data protection bill or any other law for that matter is a great way forward. So having said that, I think, where does this bill sit in that context? And I'm going to be a little brief, Kazim, and we can come back later.
Yeah.
But if you just simplify things and say that, on a scale, there is GDPR at one extreme and a Singapore law on the other extreme. I'm not trying to be accurate here, but just kind of giving a sense. Then obviously, I think from our journey from 2018, we have moved progressively from near to GDPR to near to Singapore. So that's really the journey of this bill in some sense. Now, what does it mean in terms of, is it good or bad? And I'll give you my initial thoughts. I think GDPR is a great framework, but it's too early to pass judgment. We have barely been in the 5th year, and I think regulators are just waking up to enforcement in the last couple of years. And we have to see the merits of GDPR play out, and that probably will take a 20-year horizon, if not more. So therefore, let's hold that thought. Now, one of the things which we like as industry about this bill is that it is not trying to do too many things. It is not trying to fix non-personal data. It is not trying to fix hardware certification. It is not trying to fix algorithmic fairness. It is squarely focusing on personal data. So now one may debate how well it is focusing on that. And that, I think, is the work forward that we need to do to say that does it adequately, does its primary task, which is to protect the privacy and data of the citizens. And that's the discussion, I think, which is going to be a way forward. But I think in that sense, we have come a good way, and we are hoping that finally we actually have a law which serves the desired objective. Yeah.
Thank you, Mr. Aggarwal. Anushka, I'd like to come to you. And I think one thing which I've also observed from the one which the JPC had presented in 2021, December, to this is a much simpler version. Right. This is a lot. I mean, number one, it's simpler. Number two, non-personal data is not there. It's solely looking at personal data, but then it's looking at only digital personal data, right? Whether that was the intention of the Supreme Court judgment in 2017, because whatever the data protection law will do has to follow from the judgment of the Supreme Court, the Puttaswamy judgment. I'd like to ask you, Anushka, what's your take when you look at the bill from an individual rights perspective? Sensitive personal data definition has been removed. There's a lot of debate on deemed consent. It was there in the last draft as well, but it calls out more in this draft. Government exemptions still remain. Data Protection Authority looks weaker than before. So, and of course, I think there are 18 times the bill is saying as may be prescribed, and that is something which IFF had also written. I think there was a meme also on the internet around this. So do you really feel that it's a simpler version or it's a watered down version of the draft? And does it really do enough to protect individual rights tomorrow in the digital economy? So what's your take on that?
I think, because you mentioned Puttaswamy, let's just think about what Puttaswamy did. Basically, it said that the right to privacy is fundamental. And then they said that informational privacy in today's economy, it's very important that it is included into the right to privacy, and that the government takes steps to protect the right to privacy and the informational privacy of Indian citizens. So that is the baseline that we are coming from. And if you look at this bill, I don't think it's doing enough to do that. First of all, like you said, it's restricted to digital personal data.
Right.
It's extremely restrictive. There are no protections which are given to sensitive personal data, which is a category which should be recognized because by its very nature it is sensitive and it needs a higher degree of protection. But that kind of depth of drafting, I think, is missing, which leads me to my next point, which is that, yes, it is a simpler bill and it's a shorter bill. However, I feel that we have sacrificed depth and actual impact at the altar of simplicity for this bill, because this bill is not really doing what it's supposed to do in a lot of places. We don't know how data transfer outside the country is going to happen. We don't know on what basis the Data Protection Board is going to be made. We don't know on what basis, multiple things which are important things are going to happen. So a lot of this has been left to later executive drafting, which will also exclude parliamentary scrutiny. It will exclude the fact that civil society stakeholders and other stakeholders will be able to meaningfully engage with it. So I think definitely this bill falls short of going back to that baseline of protecting the informational privacy and the right to privacy of Indian citizens, which is where we started in 2017 through the Puttaswamy decision.
Right. We'll come back to you a little more to discuss a little more on that. Nikhil, I'd like to come to you. So I think Anushka made three very important points. I think what I see, number one, they've sacrificed depth to make it simpler. They've left a lot to rule making, and I think her point on rule making also is valid in terms of will there be enough consultations. But I think over the recent past, in the last 6 months, we've seen the government organize consultations, be it on the bill or even on the IT amendment, IT Rules 2022. I know you're smiling, so I'll wait for you to respond. But specifically to you also, Nikhil, you please welcome to respond to what Anushka and Ashish have said. But what do you think the bill does for the startup ecosystem? Because one of the arguments which we've seen in public, and we did a study as well, was that data localization, strict localization, would actually restrict startups' abilities in many ways, and that has been relaxed. Of course, how you notify countries is different, and Ashish can come on that part as well. But generally within the startup ecosystem, because you talk to a lot of startups, you engage with a lot of them, and I know you're friends with a lot of founders as well. So what is the startup community thinking about the bill?
So before I get to that, Kazim, I'm going to take a slight step back. Right? The thing that's changed between, let's say, 2010-11, when that first version of the bill that under that government had come out, or leaked rather, is the explosion in this devices, right? These are essentially surveillance devices. So whatever we're doing, whatever we're seeing, our microphones can be switched on. We are all being surveilled all the time by ourselves on these devices and by the services that we're using. And by extension, because these devices, and say when there's a search and seizure, they can be taken by the government. And under this bill, there is absolutely zero restriction, as far as my reading is, and I'm not a lawyer, so I'll talk about it from a user's perspective, on the government accessing all of our data. So for all of us sitting here, for all of us watching, we are under constant surveillance because of how we behave. And what this does is that it creates a trust deficit. So I don't trust an app because I don't know what it does with my data. I don't trust the government because, well, they have statutory power, they can use my data against me, they can fabricate information, put information on a device. So the purpose of a data protection bill is to build that trust in society for all of us here. Does this bill do that? I don't think so. So I wear many hats. I run a business, I'm a journalist, I invest in startups, I am a common citizen. For each of those hats, I can say that this bill fails me. And for each of those stakeholder groups, it fails us, right? Because economic activity is also contingent on there being a trust in the market. And globally, we have a market failure in privacy, in data protection. So whether you've seen what's happened with Cambridge Analytica, whether you've seen what happened in this state in the last election in 2019, where allegedly Aadhaar data was being used by political parties for electoral campaigning, this is the problem. This bill doesn't solve any of those problems. So I don't know where to begin, because with each progressive version of this bill, we thought there were a few things that needed to change with the 2018 bill. We were all critical of that. But with each progression, it's got worse. This, by far, is the worst of the lot, because it does literally nothing to protect what it's supposed to protect, which is our personal data. It doesn't protect, for example, students. I was in college when I was 17. I can't imagine needing parental consent to access a website or use an app and have them verify me. I can't imagine running a business and having to do KYC for every single one of my users. The friction is such that they'll stop. I'm investing in startups. I know that startups will, they will find it very, very complicated to onboard people. It will increase cost of user acquisition. To your point on data localization, at a global level, when you're running a business, you use, and when you're running a startup, you use multiple services. You don't even know where those services are based. It could be in Brazil, it could be in Vietnam, it could be in Indonesia, it could be in the EU. So, and I know Ashish will disagree with me on this, but my reading of the bill is that unless there's a white list, it is a black list. So all data for Indian citizens will have to be localized in the country, which means as a business, I can't access any of those services because processing personal data is a part of it, unless that country is whitelisted. So a lot of things will just fail in the way they're working, even as a business. Right? So what we're dealing with here is a complete ignorance, or rather not ignorance. Like I was talking to people in the public policy space. Startups at this point in time don't care about the data protection bill. Most of them, smaller startups, anything that's not a unicorn doesn't care, right? For most of them, policy is reductive, which is a negative thing. They'd rather focus on growth. They will focus on this when it passes. But when you look at the public policy space, there are people who are not participating in this government consultation on this particular version of this bill because they're like, the government doesn't care. We've participated in every stage from day one, and this is what they come up with, where they've just taken every single submission in the past and just put it in the dustbin. So I hope there's another bill for consultation, to be honest, because if they make minor modification to this, it's a disaster. There's no point of having a data protection bill that is this bad. For users, for businesses, for people, for founders, for investors, it's a disaster.
Okay, good, interesting. I think that will, the conversation will be a lot more livelier now, I'm guessing. Ashish, I want to come
move your mic up though, we can barely hear you.
Okay,
Yeah.
Can't, oh. Can we check the sound?
Just move it up. Just move it up.
Okay, better?
Up here, put it on the corner. It's too low.
How about now?
Better.
Perfect. And I hope there are questions within the audience, so please feel free to sort of raise your hands. We'll come back to you whenever we have the time. But Ashish, I want to come to you. I think few points Nikhil made. One was trust. I think that's a very valid concern. And that's a concern with any new regulation, right? How do you build trust within the consumers? As it is within the digital economy, I see there's a big gap of user trust with, the tech ecosystem and users using the platforms and using different services. There is a lot more which we can do to sort of bridge that gap. Very important point on checks and balances, and if Anushka wants to come into that as well, we would like to sort of focus a little more on the exemptions and a little more on how the regulator is functioning, because we feel that the regulator is not as empowered as it should have been. Spoke about children definition. I think that's a very, very valid point for a lot of fiduciaries, for a lot of players, for a lot of platforms, and even for the users and young children, at the age of 15, 16, using the internet for various things, building things on the internet. How does it play out for them? So would sort of come back to you on some of these points, but also if you want to touch upon how Clause 17 will work out with respect to notification. I know we've spoke about this previously as well. But how will it play out? How will India really whitelist countries? And if we were to believe what Nikhil is saying is true, that data is of course scattered all across the geographies, then will you just be whitelisting every country, and then suddenly one business cannot transfer data to a particular country if that is blacklisted? But what happens to existing data transfers taking place? Standard contractual clauses. What about binding corporate rules? What about company-to-company data transfers? So just your opinions on that.
Thanks. So I must say that debate is getting interesting, and thank you. So before I come, Kazim, to this, I want to maybe add a little bit to what Nikhil said and maybe what Anushka also said. On the children point, I think the law is overprotecting children by requiring parental consent. So I wouldn't say they're underprotecting. And that's a problem. You shouldn't overprotect children to that extent, and you want to make sure that that sort of a thing is fixed. And it can be fixed because the concept of different classes of data fiduciaries can be brought in under the children kind of a regulation in terms of that section. Other thing which I was mentioning when I initially talked about, right, from an industry point of view.
Can I just quickly add something to Ashish?
Yeah, please.
So the way I look at that particular clause is that it's starting with blacklisting everything for someone between the age of, below the age of 18, right? Including.
I'm agreeing with you.
No, I'm saying it's a blacklist. What it does is it removes agency from a child when they're growing up, right? Or when they're coming to terms with things that they need to look at, right? But most importantly, it starts with a blacklist.
Yeah,
So where we've seen in, for example, in the UK is that you've identified specific entities that where the data processing is higher, where the potential for harm is higher, and you're putting those in a list that need to be where you need parental consent. Here, everything recurs. So I know we are agreeing, but I just want you to add that context to it, that agency for me when I was 17 is extremely critical.
Okay, so I think the main point which I wanted to make here was that the law is probably overprotecting by saying that for everything you need parental consent. And dwelling a little more into this, in UK the age is 13. Actually in UK you can enter into a valid contract from age 7, though the contract is voidable at the instance of the child, and therefore the reliance of the entity on that contract is to some extent precarious. So I think through geographies you will have different contexts, but what is desirable to be fixed is that you want to make sure that you treat you treat teenagers differently, you need to treat maybe a 7-year-old differently, and that can be fixed in the law. The second point when I want to talk about the same example is that you want to have a system of verifying age of the child, of the parent, good construct. But unless you have technological solutions which are available at scale and in a manner which is convenient to be able to do it in this kind of a environment, to adhere to this kind of a provision, you would have to go back to even GDPR, which says reasonable effort. So, but zooming out of this, I think when you look at this law and how can we now focus on improving this from the point of view of citizens, what are some of the things that can actually be done? So one, the explanatory statement to this law calls out purpose limitation, data minimization, but it is not explicitly called out in the bill itself. So I think once you put that as a principle in the bill, it places a big obligation which should do us good. The second thing which it doesn't call out is you have to comply, but you don't have to demonstrate compliance. So I think adding that word that also have the obligation to demonstrate compliance will add a lot of focus on this bill. The point which Kazim wanted me to talk about, transfer provisions. I think, see, roughly you have 200 odd countries in the world. So even GDPR, it has done 14 adequacies, out of which 7 are countries which are probably too small. So, and it has been now, we are in 5th year. So adequacy is a long drawn process. So I think our law, when it wants to notify countries, it has to move away from that concept and rely on a range of schemes so that the obligation can shift partly to data fiduciaries and to the importers who import this data, and from a government point of view then look at entry into bilateral and multilateral arrangement to make sure that they have enforcement capabilities. So I think a lot of these things can actually be fixed in the law. When you talk about deemed consent, I think what is, if a consumer has a problem with that, then how is it going to be able to, go back to the government and say that my consent was not taken properly? I think those are some of the things that can be addressed. And finally, when you look at the fact that one big potential discussion point in this law is that we don't have a full-fledged authority. And that is, in some sense, a gap, and we don't really know how that will play out. But if you look at the functioning of the board, if it can handle this one job that it has been entrusted well, which is handling redress and doing it in a manner where people are encouraged to complain, I think that would be one big part which can actually be, very valuable in terms of impact, and which is something we are seeing even in GDPR. It's very early days. So I think this bill is in the right direction. Some of the gaps can actually be fixed, and that's what we as industry are now focusing on.
Anushka, I'll come to you, and then Nikhil, you can respond. So one is, as a rights organization, I think one of the questions which I also have for you is, does it really meet the sort of the standards of privacy? When we talk about data minimization or purpose limitation, we also see that the bill doesn't have any mention of privacy by design, which was there in the last draft. And it doesn't really talk about it in this draft. And, of course, a little bit more on, I think, what Ashish spoke about, regulator. And I think this is also cutting across all stakeholders, that we all feel that the regulator is a little weak in this version. I think the last version was a little better when it came to the regulator. And of course the government exemption, which of course Nikhil had spoken about previously. But just looking at, if you were to rate it from where the Puttaswamy judgment was and the test of proportionality, legality, necessity, does it really qualify that?
Like I've already said, I don't think it does, because if you look at what the Puttaswamy decision said, that any state invasion has to be justified through these specific standards, and necessary state aim, proportionality, where the invasion is not excessive and it's balanced. I don't think that's happening here, especially because if you look at the exemptions that can be granted or the deemed consent clause, both of these clauses are extremely wide. Deemed consent can be deemed, which is basically non-consensual process.
Can you explain that a little bit?
So clause 7 says that consent is this. It is freely given. It is informed. I don't think consent is informed under this bill as well, because the notice requirements are weak.
Okay.
Right, they don't have to tell you if they're going to transfer it to a third party. They don't have to tell you if they're going to transfer it outside the country. They don't have to tell you what they're going to, when they're going to delete it.
These are both private and public actors.
Yes. So these are not included in notice requirements. So I don't even think that consent can be informed in this bill. So that is what consent is under clause 7. Now clause 8 says that in certain situations we can deem consent. And the first 8.1 says that when it's basically it's flowing from what you've consented to, which is okay. But the other sub-clauses under that clause, that is what is non-consensual processing, because it says that we will do it for maintaining public order or in public interest, we will do it for employment purposes, we will do it for security purposes. So all of these purposes, if you're deeming consent, basically you're saying that we will do whatever we want to do with your data and your consent does not matter. I think in a data protection law, it's very important that consent is the cornerstone on which the framework is built. Coming to the exemptions.
But can you also make it very explicit every time? Doesn't that become onerous for a data principle?
That is
How
what?
do you strike a balance?
That's the restriction that will be there on the data fiduciary or on the data processor, right? If they can't get the consent of the data principal for a specific purpose, then maybe they should not do that processing, right?
Okay. Okay, I see hands.
I can explain.
Yes.
So deemed consent is like, if you go to a restaurant, you give a number, you don't need to sign a contract, right? And then they can collect your personal data there. But here's the thing. When you go to a restaurant and give your number, do you also give them permission that they will make a note of what all you've ordered, collect that data, put your contact details and give it to a third-party aggregator that is basically profiling you and what you're eating at each restaurant and then selling that data to other restaurants so they can start a new restaurant? You don't, right? So if I'm going to a restaurant giving my number, but if they also want to do all of this, then they should need to sign a contract. It can't be deemed.
Every time they are processing your
So the
data.
principle of proportionality is saying where there is an extension of usage of my data, there needs to be a proportionate restriction. right? That is not coming in.
But it's
What's happening? That's what Anushka was meant about third-party data sharing,
What
right?
is reasonable purpose? That's not defined,
So
right?
I want to
Can
get
I
Ashish
quickly, though I'm not a lawyer, but having listened
I'm also
to
not
enough
one.
of them. So, see, I think we need to distinguish between grounds and purpose. So, just because you use deemed consent to process data doesn't do away or kind of, reduce the requirement for your purpose to be there. So if I am using that same analogy, if I placed an order at Starbucks and they want my phone number to call me, then they can only use that phone number to call me. If they use it for some other purpose, then it is not that deemed consent, because the idea of deemed consent is that you have given your consent where you couldn't give the consent in the manner required in section 7 through your actions. And that doesn't mean that now you can use this data for some other purpose. So grounds and purposes need to be clearly understood.
Okay.
And I don't think this bill says that just because you can use deemed consent as a ground, you can now use the data for any purpose. So that is not the understanding of the bill.
No, I think that's 8.1. The other subclauses of 8, I think that
So
they do allow.
let's have a
And
different-
also, I think the exemptions clause also allows them to exempt.
I have another analogy.
I wanted to actually talk a little bit more about deemed consent, so when you guys are done, if I can just
Yeah,
jump in.
I have another analogy, and Nikhil, you can respond. Let's say there's an app. We are in a pandemic. There's an app which is collecting data for whatever purpose. I mean, of course, the purpose is to make sure that we are rolling out vaccines, and we understand how the pandemic is spreading. Pandemic is now over, at a situation where there is no chance of its coming back. If that data is used for any other purpose, is it like deemed consent in that case?
Yes,
Is it something
because
which the
they
bill
say
provides for?
for reasonable purpose, or for public health is a reasonable purpose.
So you're saying that the definitions are too vague and too broad.
Definitely too
Nikhil,
vague.
you want to just respond, and Ashish maybe?
So a couple of things about deemed consent, right? One, as Anushka also said, there is no notice requirement. So if someone's taken my data for the purpose of, let's say credit scoring, operation of search engines, recovery of debt, processing of publicly available personal data, including, let's say, someone scraping all of your tweets and your profile and things that you put out publicly, and then creating a profile of you separately in a database, or a surveillance software like Clearview AI is basically scraping your photographs from wherever they're on the web and then using that. You don't even know that they're doing that. So that's the failure of notice, because if you notice, then you can withdraw consent, right? In this case. So that's one part of the problem. The other is the recursive nature of deemed consent. If I know that let's say company X is processing my data, and I want to withdraw that consent, and I say erase my data, they can deem it again. So it's an infinite loop. How does this work? Right? So I think that's bad drafting in law. Let me finish a couple of points, right? Secondly, there is an exemption for credit scoring for deemed consent. How does that work? Why should someone be able to profile me and do a credit scoring of me? What does China have? Social credit system. People are barred from taking flights if they don't meet a particular... So why is it that I'm allowing someone to scrape all of my data, take all of my data without my consent so they can do credit scoring, right? Recovery of debt, that's a problem. One of the big problems with the payday loan, the salary loan startups, is that they take access to someone's entire device. They have photographs, they've got contact details, and then the recovery agents start calling up people to saying that, they say that, we'll call all your contacts and tell them you haven't paid the loan, or we'll take your photographs and make them public. They threaten them.
Yeah.
Instead of protecting that person's privacy, you're saying once you've taken a debt, you own everything. There's deemed consent. What sense does that make? I mean, look, even for electoral purposes, one of the things that I really want to use a data protection bill for is to know how political parties have profiled me and what data they've collected of me from where. That should be my democratic right. But this gives political parties a complete exemption. So this bill does nothing to protect privacy, is what I'm saying.
Ashish?
Okay. It destroys everything that a privacy bill should stand for.
Okay, all right. So I think we should just remember one thing, that the purpose has to be lawful. Second, just because you have used deemed consent, if you do something which is criminal activity or unlawful, this doesn't legitimize that. Second thing is that just because you're using this as a ground, you can't deviate from the purpose. So having said all this, let's take where I agree with what Nikhil just said. Let me just complete. I'll just complete. When you look at publicly available data, just because something is publicly available doesn't give somebody a right to process it in a manner which is unfair to me. So I think that is clearly a gap, and that probably needs to be fixed in the bill. And that can be done through drafting, and that's the initial position, right? That how do you fix this? Secondly, employment purpose. So now this bill says that for employment process, you can process it based on deemed consent, but you can only process it for legitimate, lawful employment purpose. If now you process it to discriminate against me in a manner which is otherwise not permissible, then obviously you are guilty and you will be hauled up. So I think we need to go back to think, what is this law trying to do, and how does it sit in the context of all the other laws that are there, and then we will have a little more clear picture where we will be able to say that, okay, fine, am I protected enough or not? Thanks.
Just one thing that...
And I also like to discuss the rights or duties of data principle, if we have time.
Yes.
And I hope you all have some questions.
So one thing that Ashish just mentioned right now is that whatever they're deeming consent for, it's a lawful purpose. What is a lawful purpose under the bill? A lawful purpose under the bill is anything that's not illegal. There's a legal vacuum in India. We don't have laws for a lot of things. We don't have laws for a lot of cyber crime that happens. We don't have laws for a lot of surveillance that can take place. Does that mean that just because it's not illegal, you get to do it?
If you're harassing somebody, then I think there are laws to protect people from...
So there are some, but there are also not a lot. There is a legal vacuum when it comes to how the internet is governed in India, how data is governed in India. So if we take that approach that lawful is what is not illegal, then I think that is where the problem comes from. So just saying that, because that they're deeming consent for lawful purposes is not enough, because the bill defines lawful purpose as something that is not illegal. And there is a legal vacuum.
There are, in the CRPC, of course, a lot of the sections,
definitely
they do deal with some of the issues related with the internet,
yes.
even today.
But even that, we're trying to reform that, right? We're trying to do criminal law reform for CRPC, ITA Act is getting reformed, everything is getting, IPC is getting reformed. So that means that there is also awareness that there is a vacuum.
Getting changed, not reformed necessarily. We don't know yet.
Yes. Another thing, just one more thing, because you'd asked me about the regulator before. I don't think we can call it a regulator anymore. It's just a board now, and it's just going to listen to complaints or grievances that arise. It's not regulating. It's just going to give answers to, okay, are they in compliance or not? It's basically just an adjudicatory body at this point. And what will happen, because they've also restricted the jurisdiction, is that it could end up in a CIC, Central Information Commission type situation, where it takes at least 1.5 to 2 years for somebody's complaint to come up. So for 2 years, your data is getting violated, your privacy is getting violated, while all the the backlog is being cleared by the Data Protection Board. So I think that is also something that we need to see, that it's not really a regulator. Calling it a regulator, I don't think we can call it a regulator anymore.
No, that's a fair point, and also how will it function with other regulators? There's not much defined in the law. They've taken away the MOU clause as well in terms of how it should work with, let's say, the RBI or whatever that is. But important point on CIC, and taking from that, the last clause, I think the second last clause also talks about right to information, and that the fact that Right to Information Act is now going to be amended, where personal information related to any query now will be denied. So I think that's something which also is being studied. But I want to come to Ashish, and I'll come back again with one other round. But quick respond, and then Nikhil, and then we'll take questions.
Okay, so the RTI amendment, that should not go, because RTI Act has enough safeguards, so that's not really necessary. On the point that, deemed consent again, when you look at purpose, if the purpose is granular enough, then I think it takes care of these kind of issues. On the board part, look, resolving complaints against data protection violation imposing penalties is going to demonstrate the success of the bill as far as stakeholders are concerned. So I think the point really is that we are in a journey. Europe has had 30-year journey, and they have put out a law which will take them 25 years to figure out the cost-benefit analysis. So if we can now do this well, and that's where the focus is, I think then you get to a stage where you actually are able to give privacy protection and test it out. And I think the rules, while some of it can be more encoded in the bill, but to some extent we have seen over the last few years, and this is a trend, that unlike earlier when law got enacted and we had the same law for multiple decades, now you are having laws which are getting routinely amended every few years, and the rules getting amended even more frequently.
Very frequently.
And in all of that, we have seen public consultation, and that again needs to be hard-coded in the bill. But I think that is the journey. So it's like saying that, you can't design a software knowing all the functionalities when you don't know the functionalities that well. So you need to have the core system and then build functionalities as you come to the use cases. So I think in India, we need to take that kind of an approach so that we ultimately get a software which we want and we can use, rather than having a lot of functionality and then figuring out, okay, it is a mismatch or some of it doesn't work.
Just like we make mistakes on the way and then improve, hopefully. But Nikhil, quick points, and then Anushka, quick points, and then open to the floor.
You can also not learn from other people's mistakes. Like you can't come with something that's as disastrous as this bill is. You can't even learn from previous versions which were substantially better. The first version was substantially better. But I just want to the Sri Krishna draft, right? I want to go back to where I started, and then after your round you can go to questions. But it's about, like I said, one of the problems with this bill is that it largely gives a complete freedom to the government to surveil us, right, as citizens. But what it also does is creates a situation of privatization of surveillance in a different way, as in every single app, every single private party that you engage with is collecting data about you, and there's literally no restriction on the government to take that data from them to profile you. Go back to something that was planned again under the Congress government and is still being operationalized, but one of these days it could become operational. There's something called NatGrid. It's a national intelligence grid, right? What it does is that it provides real-time information on an individual. Version 1 of that particular program said there will be 21 public and private databases. Version 2 was 900 plus public and private databases. Version 3, 1600 plus public and private databases. So what you're doing here is using a bill that's supposed to protect us, creating a framework and enabling lawfully, effectively, a mass surveillance mechanism where we are basically compromising our privacy and putting ourselves up for surveillance all the time, using the apps and services that we use. And that's a huge, huge, huge problem that violates the entire, that goes against the fundamental right to privacy judgment.
So
and what it does is once people realize that this is happening, that the government can go to any company and take your data from them, it starts eroding trust
in the users.
And that impacts the economy, that impacts, I don't see it, I strongly believe that the incentives for users and companies are actually aligned. It's only some instances, for example, a friend of mine said a few days ago that there was a startup founder whose company shut down. He had data of 2 million users. He was willing to sell it to anyone willing to pay, right? I don't know if this bill prevents that from happening. Why not?
Fair enough. Anushka, final points? Ash, you want to respond, so we'll give you after Anushka is done.
I think we need to, and this is where I started again, I think we need to go back and think about what this bill is for. Whose interests is it going to protect? Is it going to protect user interests? Is it going to protect the company interests, or is it going to protect the government interests? As a civil society organization, we believe that this bill should protect user interests. It's the data protection bill. Whatever you call it digital personal data, you call it personal data protection, XYZ, ABC. the point of the bill is to protect the right to privacy of Indian citizens, and that is what the government is supposed to do. That is what they're making these laws for, to protect Indian citizens, right? And then we come to the question, is this bill doing that? And I don't think it is. I don't think it is because of how it's not giving notice, because of how it's deeming consent, because of the wide exemptions that the government can give to itself and to private actors, which opens it up to a lot of lobbying again. Same with the data transfer clause. So I don't think it's really protecting citizens, what it does for children, how the age gating is happening. So are user interests actually getting protected? Is it data protection and is it data processing? And this is something we put out in our submission for the bill as well, that this is not really a data protection bill, it's a data processing bill. It's telling you how to process, it's not protecting the interests of, and one of the biggest reasons why that is also because of the toothless data protection board. I mean, the chief executive is going to be appointed by the government. All of the rest of it is up to the government. Will the data protection board actually be able to protect the interests of the users? Or will it end up protecting or even giving more weight to other interests, company interests or government interests? Right, so all of this needs to be fixed. And we believe, at least at Internet Freedom Foundation, that the way to fix it is to recall this bill and go back to the previous version, which had been developed from civil society and other input through years. I mean, they've junked the entire input that they had gotten through multiple years, everything that the JPC worked on for 1.5, 2 years, and then they've given us these 30 clauses. I mean, it is in 2023, we are talking about a bill that somebody should have made in 2002. I'm not ashamed to say it. This is a 2002-2003 bill because of how much it lacks. It does not have anything, right? So yeah, that's how I feel.
Thanks, Anushka. I mean, of course, there are very strong opinions on either side, but Ashish, just to quickly conclude, one point which Anushka said very pertinent is supposed to protect user interest, but it's not. And of course, there are stakeholders involved. Companies have to do business in India. There is a digital economy which has to grow. The processing of data will happen, right? So how can we arrive at a law which protects the user interest, but at the same time, you're not deviating away so much that you're also sort of protecting the interest of, let's say, the fiduciaries or allowing them to do business, but you are really protecting the user interest practically on the ground. Like, can we arrive at a law which does all of this together? Or is it too much to ask for?
No, Kazim, I don't think it's too much to ask. I think the purpose of this law should be single purpose to protect the data of these citizens and users. So you can't have multiple objectives really there. Having said this, I think it has to be a smart law, which doesn't cause so much, which is not a bull in the China shop kind of a law, and which actually does this in a manner causing least damage. And that's the balance. So it's a good thing that after having had all the discussions and listened to all the inputs and got to where we were in JPC, government took the brave step of saying, now let's come back and do what's really useful. Having said this, I think there are, again, I'll give you a couple of examples. One thing which can be easily fixed. In the current IT Act, you have a provision which says that if you are asking information from an entity, you will give a notice in writing specifying the purpose. So that same thing can be actually carried forward in this bill, which will partly address the issue about government access to data in some sense. So RBI governor is appointed by the government, by the way. So there are mechanisms in which we can strengthen this bill, and the assumption that just because government has flexibility, it will do all the wrong things, it is a fair point, but it is not necessarily a very realistic point of view in our understanding. And this is where we need to work with the government to make sure that we get somewhere. So the last thing we would want the government to now do is to recall this bill and set us back potentially by another 4 years. So what we as a nation actually need is a privacy bill to get started, and we will obviously improve as we go down that journey.
Great, thank you so much. Any questions? I hope there are a lot of questions coming in. It's still early in the morning, but the discussion has been quite lively, so I hope there are questions. Okay, I see one hand. Sharik has his hand raised, and then another one. So we'll take Sharik's question first, and then we'll come to others. Please introduce yourself. Sharik doesn't need to be introduced. Everybody knows him.
Thanks, sir.
It's still off.
Hello. I think we just had one of the most interesting discussion on data privacy of this year. Thanks, everyone. This is one thing which I keep discussing with most of you in person. How do you see, like we had, since Justice Puttaswamy judgment, Shri Krishna Committee report, and all the previous drafts that we saw, and we have so much of consultation work that was put into effort, drafts and all. And Anushka, you have this, draft box where we discuss everything. And how do you all see the current report draft we have in light of the previous consultation that was taken? That was the whole exercise that was done by the civil society organizations, by the media, by the industry bodies. And why don't we discuss that? What happened to that previous consultation? And as a civil society, why don't we talk about it? I mean, I don't see that discussion happening.
Very easy answer, right? They just took everything and put in the dustbin.
I
That's
also
it.
want to know what happened to that previous version.
And
So
I think-
I have the same question. I want to know what they did with it, because we spent a lot of years on it, right? Everybody spent a lot of years on it. And we can't really see the learnings from that, or even from Puttaswamy in this version. So what did they do with all of those consultations is something that I would also like to know. Yes.
I would think this is an outcome of the consultation and not what they did with the consultation. And a lot of work has gone and all of that. And if we can actually do something, so what is a good job of a public policy person like me? If my job is no longer required, that's the best outcome, right? That things are solved and you don't need a public policy function to be so big. And I think to some extent, this is where we should strive our laws to be, not in a situation where we actually require tons and tons of lawyers to clarify and interpret and then to deal with the laws as they come in. So I think we do need a agile law. Yeah.
I think as researchers, definitely the last 4 or 5 years, there's a lot of good material which was compiled, published by a lot of organizations. So I think at some point of time in the future, even now, it's very relevant in terms of theory, in terms of conceptual understanding of privacy. So would request students to, if those who are really interested in privacy and digital economy and data protection, to peruse through that material. And Medianama has done great work. NASSCOM, of course, has been doing it. IFF has been doing it. And we, of course, have also been involved. So that material is still there. So that is not going to age, I feel. And that is going to be very relevant even 10 years down the line. A lot of the briefs which have been written, a lot of the papers which have been published. So it may come into use further later on. It may not have come into use now as much as we would have liked it to be. But I do feel that is going to be relevant even in the future.
And unfortunately, many of the submissions that have gone in are still not available in the public domain because they're going against the pre-legislative consultation policy and not releasing it. So therefore, you don't have that much to work with, but we've all got compilations.
I think that's a valid point. And I think IFF recently did an RTI on the India 2.0. When you guys...
We do
we
a
will
lot
have to
of
file
RTI
RTIs
requests.
to really access documents. And I think somebody will have to file an RTI to access the submissions for the
So
draft.
that's what. So the pre-legislative consultation policy that he said, it says that you have to publish all the responses.
Yep.
But they're not doing that. I don't think they did it for India 2.0. They did not do it for telecom bill. We asked for it and they said that we will not give it because it's going to go before the parliament, so it's under exemption. For this one, in the notice itself, they've said that we're not going to make it public. So, they're going against the pre-legislative consultation policy that's there already. They're going against principles of transparency. And there's no reason for it, I think.
Maybe somebody have to file an RTI again.
Oh,
But
we filed an RTI, but let's see. what happens.
on this
Yeah,
possible
yeah, we
question.
have,
Okay,
yeah.
great. Let's focus.
There's a
on
question there.
Yeah, we have another question. Maybe if you can introduce yourself.
Thank you for this wonderful deliberation. My question is pertaining to the data concern of the consumers, like the citizens of the country. We have seen compared to Western countries, India has spearheaded in UPI, where people are transacting. I mean, like, there is a transaction of even 1 rupee simply. I mean, everywhere in Hyderabad, since I've been here for last year, I haven't seen a currency note in my wallet. So when we talk about concern of the citizens with respect to data and the migration or the adoption per se, what are your views on that? On a lighter note, their concerns with respect to understanding what goes into the nitty-gritties of the data, bill which is being rolled out, or what do you think on these aspects? It's in bits and pieces. I hope I've tried to explain something. Yeah.
So there's a misnomer, something that's been going around for a few years. We've heard it so many times, that Indians don't care about privacy, right? And that we give our data away readily. The most common example is you're sitting in a train compartment with someone, and by the time you reach your destination, some 2-3 days later, they know your entire family, entire history, etc., right? The point is, again, it boils down to the idea of trust. So people give a certain amount of data to freely because they believe that won't do them any harm. So one, there is a question of awareness of harms. The same way, if you walk up to anyone on the street and say, can you give me your health records? They won't, right? So there is even in that train journey, with each subsequent conversation, the trust increases and people expose more and more of their data as they go along. We need to realize the reality of how people behave how people behave in our country is not very different from the rest of the world. There is a vast amount of data being collected through UPI. All of that is going to go into credit scoring and lending mechanisms. There is also, there's a unique health ID that's being created, which will house all our health data. All of this is going to, through a consent framework called DEPA, be transferred and accessible to insurance and credit companies and that entire management is going to happen through entities called account aggregators. So we are being profiled not just by the apps that we're using, but also all the government services we're using, and also all the private company government supported services like UPI, like ONDC, like Health Stack, and a bunch of others. There's going to be an Edu Stack, there's a Travel Stack, there's a Voice Stack. All of that is data. All of that, and people aren't aware of the harms that the data might cause if it gets leaked. And frankly, we don't really have a culture of cybersecurity in this country. I know NASSCOM and DSI do exemplary work there, but at a government level, there's barely little. Look at what happens with the AIMS ransomware attack a few weeks ago, right? India doesn't have a cybersecurity policy. It's been in the works since 2018. I don't know when it'll come out with 2028 maybe. But yeah, I don't know if I've answered your question, but that's what I thought you were asking.
Yeah, like this was related to the digital transformation in the governments which is happening, and major aspect which I found is like the trust factor. So I was just looking at, concern like when people are using UPIs blindly, at across metros till the villages it has spearheaded, and we are 1.5 times more than China itself. So that was one aspect. And I've been reading about some reports with respect to Norway and the Scandinavian countries and how they roll out. So over there also, like the major thing they focus is trust. So, how it matters with the UPI or the other government projects with respect to making it more digital governance.
So one of the things that we've seen with government projects in terms of digitization is this idea of reduction of friction in the process. What that means is that there aren't sufficient checks and balances in place, which is why you're seeing the scale of UPI frauds that you're seeing, right? Fraud detection is not... The other thing with UPI is that you're pretty much exposing your entire bank account whereas if you look at the credit card system, there's a limit and you have the freedom to set your limits so people control. In fact, people who are aware in case of the risks of UPI, even though it's growing exponentially, are also being smart about it. I know people who are using a bank account with a limited amount of balance specifically for UPI, because it's become easier to open a bank account. So I'm saying we have to balance digitization, digital transformation, the reduction of friction with also better protection. So this bill doesn't protect us that well. We don't have we don't have a cybersecurity policy, we don't have adequate protection from technical implementation and auditing of entities that are hosting vast amount of data. I don't know if you remember, but Rasna Khera's story on Aadhaar, right? What she found was that at the Common Service Center level, and this is 2016 maybe, 16, 17, that at a Common Service Center which was being used to enroll people in Aadhaar, the operators were selling admin access to the Aadhaar database with read-write functionality, so anyone could basically become an Aadhaar admin and get access to all the data. Right? They filed an FIR against Rasna for doing that story, and then they eventually withdrew it after there was global criticism. But they never really acknowledged the problem that was there. Right? You have had cases in UP where for Aadhaar enrollment, fingerprints have been cloned for the operators, the GPS location has been modified, like the software that's being used has been modified. People are ingenuous about how they are breaking the system. Unfortunately, we're not doing enough to protect. Go back to 2013 and 14, you had government departments publishing spreadsheets and publishing databases with people's name, phone number, address, parents' names, Aadhaar number, mobile number, all of that publicly accessible. I downloaded some of those and reported on the fact that this is happening. So I guess people are more conscious of privacy than governments are conscious of people's privacy, is what I'm seeing.
I think it's also, the awareness is rising. I think a lot more people are now becoming conscious. I think it's definitely an issue which hopefully will become an election issue in the next few years or decades, or maybe sooner. But I know I'm getting requests from people to sort of cut short, because I think we are running out of time.
Can we do one last question?
But yeah, we can take a question, at least, because it's a very interesting discussion. I don't want to stop too early. And I'm sorry, I mean, we also started a little late. So, gentlemen over there, I think, have a question. And maybe...
Sure. So I'll keep my question short. So I'm a student of public policy at IIT Bombay, and so while reading through the bill, what I wanted to understand is, so there's mention of public interest, and the public interest will be decided by the authority as mentioned in the bill. So what about the whistleblowers who are there, who are sort of like in public interest, journalists and activists, they want to do something, they want to make some change, which in their opinion might be something that they're doing in public interest, but at the end the power lies in the policy maker, the regulator. So going forward, what about the whistleblowers who want to bring change in a positive sense, but the government may not look at it in the same manner? So how do you see that sort of being addressed in the bill, and also not just in the policy making aspect of it, but after it's the implementation of it begins?
Yeah, Anushka, you want to comment?
Yes.
Yeah. Maybe Ashish can also.
I don't think there are any added protections that are given to these kind of users who are doing this kind of sensitive work. And instead, if you look at the telecommunication bill, the draft telecommunication bill, it says that they will have to identify, that the online communication services will have to identify each user that they have on their platform, and they will also have to identify to the receiver the person who's sending the message. So if you look at all of these frameworks together, and that is how I think the government wants us to look, like, telecommunication, data protection, and the Digital India Bill whenever it comes. You have to look at them together and what kind of effect are they having. They are not giving the protections that are needed. They are not giving protection to sensitive personal data. They are not giving added protection to people who are doing sensitive work. Instead, they are making these kind of requirements for licensing under the telecommunication bill, where the online communication service provider has to identify, basically violate the privacy and violate the anonymity of that person who's trying to do something like whistleblowing. So in that situation, I think the government has not really thought about these outcomes, or even if they have thought about these outcomes, they have thought that this is not an outcome that they want to give importance to, which I think is another failing of this entire framework.
Ashish?
I completely agree with Anushka. I think the telecom bill point is disproportionate, and also you need to have clear exemption for journalistic purpose. Having said that, I think one should also say that if somebody is rightfully doing a whistleblower function to expose something which is illegal, then just the fact privacy therefore is not a safeguard in that. So that is a concept that you can keep in mind, but definitely this is an area which can be strengthened.
No, but if you look at the right to information amendment that they have now put in place.
That should go away, I see.
Yes, exactly. So exactly. The right to information amendment that's there, that removes the public interest disclosure exception, and now they've said that
ironic.
any personal information that the government holds, it will not be shared under this one. And so what they've done is they've removed that requirement that if the disclosure is in public interest, you give the information. So basically, again, like, yes, and I think everyone agrees on this point that journalistic purposes should be protected. However, I don't think it is.
One last thing, and I'm not a lawyer, but I don't think in law itself the phrase public interest is defined anywhere. It's only in case law.
Actually,
so
it's not. Yeah. Even national security is not defined.
Mm-hmm. National security is not
so instead of defining national security, which will help bring about proportionality of violation, for example, the same exemptions for surveillance can't exist with national security concerns and public order concerns, right? But like I said, who does this protect? This bill? The government. Who does this expose? The people. We get impacted. This is not a data protection bill.
So, I think we can't take any more questions because otherwise the panelists waiting for me will start hating me. So, I'd like to thank Nikhil, like to thank Ashish, Anushka for joining in, and thank you all for coming early in the morning, listening to us. Just a final point, I think what Anushka also mentioned, there's a telecom law which is also in draft stages. The new IT Act will be amended. So when we talk about privacy, when we talk about user protection or users at large, it's not just a privacy law. There are other laws which intersect with the privacy law, and I think you need to look at those laws as well, read them together to understand how user rights are protected, whether they are really being protected, and how the laws are trying to, or whether they are really successful at supporting innovation and driving digital economy. We hope the new privacy law will come soon with necessary changes and evolution, which I think the panelists very well spoke about. But thank you all for joining in, and thank you to Team ISB for having this discussion. The public consultation for the data protection bill has been closed, but you can still write into the government, you can still email them, you can still reach out to them, because I do feel that this process will continue for a few months at least before the bill goes to the parliament. So please continue to write and do access publicly available documents and publicly available information which is out there on all our respective websites. So thank you all for joining in, and I think we'll sort of conclude with this. Thank you.